the city prosecutor of Tarlac City. And so he fears that there will be no independent investigation and moves for the inhibition of the entire Tarlac City prosecution office, because the connection is with the chief of the office, and he fears that everyone in that office might be pressured. So he seeks the inhibition of the entire Tarlac City office. When the Tarlac City prosecution office grants the inhibition, it will forward the case to the regional prosecution office or regional prosecutor, whose office is at the regional center in San Fernando, Pampanga. And that office, the regional prosecutor, can then appoint another city prosecution office, same level. It is the city prosecution office that was inhibited, another city prosecution office within the same administrative region. So do we have another city in Tarlac other than Tarlac City? There is none. What's the next nearest city? He might appoint the city prosecutor of Angeles City to conduct the preliminary investigation. Then, from there, you can take it up. Then, other officers as may be authorized by law. Who are these other officers that may be authorized by law? The
COMELEC, Ombudsman.
You are correct in saying COMELEC, but that's only half correct. Because specifically, the law refers to the law department, not the COMELEC itself. Because when you say COMELEC, COMELEC is represented by the unbound, the COMELEC chairman and commissioners. But the law specifically authorizes the law department of the Commission on Elections to conduct a preliminary investigation and in fact prosecute. They are also authorized by law to prosecute. Actually, they are mandated to prosecute what they investigated. It is the law department of the Congress. So later on, when you have election cases, they can investigate only a very limited aspect of the law, which is violations of election laws. So they can investigate violations of the gun ban during election period, cases of vote buying, and that is without prejudice to another criminal action which falls under the jurisdiction of the Department of Justice. So in a gun ban case, there will be a case for a separate case and investigation for illegal possession of firearms, depending on the circumstances of the case. Because there might be instances where the law violated is only the gun ban, meaning that the possessor forgot or failed to secure a certificate of exemption from the Firearms and Explosives Committee of the COMELEC during an election period. But he might be in possession of the proper licenses and permits to carry. So it depends on the circumstances and the manner by which he was apprehended. You also mentioned the Ombudsman. You are correct. In cases of violations of RA 3019 or the Anti-Drugs and Corrupt Practices Act, the violations of the Revised Penal Code, misfeasance and malfeasance of public officers, and ordinary crimes that may be committed by people in the government service, including violations of RA 6713, which is the Code of Conduct for Public Officers. The Ombudsman In cases that do not fall under the exclusive original jurisdiction of the Sandigan Bayan, the Ombudsman has concurrent jurisdiction to conduct preliminary investigation along with the DOJ. Now, there is another special class of public officers employed by the Department of Justice who are not prosecutors but who may be authorized by law to conduct a preliminary investigation. If you notice, or if you might have encountered them in the past, there are prosecution attorneys at the DOJ. Why? What is prosecution attorneys? They lack the number of prescribed years of practice for appointment as a regular prosecutor. And so they are appointed as prosecution attorneys, and they are also authorized to conduct a preliminary investigation. Any questions so far? Yes, Mr. Ram.
I agree in total with your pronouncing. That's a preliminary investigation to prevent because it's not statutory. However,
It's not a constitutional.
However, once it is invoked by the accused, it shall form part of due process.
Yes.
According to the case by Justice Regalado in the case of Rodrigo versus Now, my question is, suppose a case was filed before the RTC, meaning there is a need to conduct preliminary investigation because a preliminary investigation could be dispensed with if the penalty imposable is 4 years, 2 months, and 1 day. That is within the province of the APC. What would the court do then? When the defense counsel would ask the court to suspend the proceeding pending the petition for review filed before the Department of Justice, will the RTC court proceed with the trial of the case, notwithstanding the fact that there was a motion to suspend the proceeding, considering that there was a pending petition for review before the department?
First of all, the jurisdiction of the MTC does not end at 4 years, 2 months, and 1 day. Now goes up to 6 years.
Yes.
So, if the penalty involved is between 4 years, 2 months, and 1 day to 6 years, a preliminary investigation is also required, which will now bring the MTC in the same position as the RTC in your question. What will the RTC do then? If the accused elevated the resolution of the city or provincial prosecutor to the Secretary of Justice on petition for review, and that is allowed by law, and also by the 2008 Manual of Prosecutors. What the court should look into there is, does this fall under any of the 3 instances where the arraignment of the accused may be suspended? What's the first instance? The first instance is that the accused might be suffering from an unsound mental condition. Remember this, unsound mental condition, not crazy. He suffers from an unsound mental condition that renders him incapable to understand the nature and cause of the accusation and the trial. 2, when there is a prejudicial question. For example, there is a civil action where the issue must be resolved by the court first before the criminal action can proceed. So, arraignment is suspended. In fact, the entire proceedings will be suspended. And 3rd is the instance cited by Mr. Armas, where there is a pending petition for review before the Department of Justice. Among the 3 grounds in suspension of arraignment, that's Rule 114, right? Only the 3rd one, when there is a petition for review, has a specific time limit.
Yes.
The specific time limit is 60 days. Now, the court, in its own discretion, at the first instance the matter is raised, can easily grant you a 60-day resetting or postponement. But for another 60 days, but for a resetting that exceeds 60 days, you will then need a certification from the Secretary of Justice that your petition for review has been given due course. And you should present that to the court. Without that certification, the court will now have the authority to force your client to undergo arraignment and for the criminal action to proceed. What is only necessary is that the 60 days, the first 60 days was given to you by the court.
Sir, excuse me. That was already clarified in the case of Paul Roberts versus the Court of Appeals 254 Justice Delay, that after the expiration of the 60-day period, whether there was a certification coming from the court will now disorder that because of the delay in tender by the counsel for the defense, that if indeed the crime where the evidence of probable death of the accused is overwhelming, then the court will now proceed. That was already in the case of Paul Roberts versus the Court of Appeals. The court will now proceed after the expiration of this 60-day period.
That's why I told you, the court can now
Yes,
force the accused to undergo arraignment. You know,
Yes.
arraignment is the seminal act in proceeding with the criminal action.
So that the court can proceed
Yes.
to apply jurisdiction over the case.
Because yes, that is one of the exceptions to what we
Number 4, in my deep justice.
in the arraignment of the okay. Any more questions? No more. Right. So we have these prosecution officer attorneys that were appointed by the DOJ because they lack the 5-year minimum experience in the practice of law in order to be appointed fully as regular prosecutors of the department. And by law, by the law that created them, they are also authorized to conduct and prosecute cases. Right? So now, how do the prosecution officers go through with the prosecution? How do they conduct the preliminary investigation? Remember what I told you a while ago about a certain procedure where one prosecutor who will not be the one to investigate the case will issue the subpoena. And I said something, I think something is wrong there. In order to answer that question, we will go through this step by step. What will start or initiate the preliminary investigation process? Stand up, please.
Filing of a complaint by the offended party.
Filing a complaint under oath
Under
by the
prosecutor.
private offended party.
By the offended party. Before the prosecutor.
Yes. And what will happen after this complaint under oath is filed? Hmm? What will happen? Yes.
Sir, within 10 days of filing, the investigating officer shall dismiss or issue a subpoena.
How is that done? How will the prosecution office determine whether or not it will dismiss the case or issue a subpoena? Who will determine it among the members of the prosecution office? Don't just answer in your seats. I will not be able to appreciate your knowledge. Anybody? Who will determine whether the case will be dismissed or a subpoena is issued within 10 days from filing?
The judge.
The prosecutor. The prosecutor
Which prosecutor?
which the case was already assigned.
So the investigating prosecutor. Now you know something is wrong with the practice in Bulacan, like I told you, where another prosecutor will be the one to sign the subpoena and issue it. Because it has to be the investigating prosecutor to whom the case is assigned, who will look at the complaint and see if it has enough merit to undergo investigation. And only then can they decide to issue a subpoena. determine whether the complaint is sufficient, what will the prosecutor look at? What will the investigating prosecutor look at?
The elements of the crime.
Before they go to the elements of the crime, before they go into the substance of the complaint. They will look at whether or not the conditions under the first subparagraph of Section 3, Rule 112 has been complied with. Whether the complaint states the address of the respondent, because how can you serve or send a subpoena? The address was not duly supplied. Look at the respondent. Was he or she properly identified? You will remember in your criminal procedure that when the crime is against property and the respondent cannot be sufficiently identified, it is the property that is duly identified and then a description of the respondent. Or if like we discussed last week, if the respondent has to be given an appellation such as John Doe or Jane Doe, the investigating prosecutor will look at that. And then he will peruse the complaints and other supporting affidavits, and that's when he will see whether or not there is sufficient evidence to support the finding of elements. Because as you know, as you have learned in your criminal law, each crime can be broken down into several elements. If one of the elements is missing, then you have no crime. It proceeds from the Latin maxim, nullum crimen sine poena sine lege, or lege. There is no crime without a law prescribing and punishing the crime. So it has to fall into certain elements. One of the elements is missing, that's enough crime. But because everything is anchored on probable cause, even if one element or two elements are missing, they'll still file it, especially if it's a drug case. Are there any police officers here? No police officers? That's the predicament of the police officers now. They have to file cases. And they have quotas to meet. So the prosecutor will also look whether a sufficient number of copies was filed, etc., etc. Now look at this. If there is a requirement that the affidavits shall be subscribed before any prosecutor or government official authorized to administer an oath. Have you ever encountered a prosecutor who accepted the oath administered by an officer, a public officer, other than a prosecutor? Who are officers, government officials, authorized by law to administer an oath? Can you give me an example? Now, you will try to approach it from a microscopic level. Who is the government official authorized to administer an oath that is most accessible to a complainant or any other party? Can you think of one? A barangay captain, o punong barangay. Can he administer an oath? Can he administer an oath? By virtue of his election,
can administer an oath.
Who else? It's very accessible to the parties. A commissioned police officer under section 50 of the PNP law. A commissioned police officer, meaning those with the rank of lieutenant upwards, may administer an oath. Who else? It's readily accessible to the parties. Huh? Who else? About the municipal mayor? Can he administer an oath? Yes. The municipal mayor can administer an oath. You see how your minds have been conditioned? But have you seen a public prosecutor who will conduct a preliminary investigation and accept the oaths given by these people, administered by these people? I have yet to see a public prosecutor who will accept that. They will always require another prosecutor to administer the oath. What is it with these people? What is it with these people? Huh? They fail to understand and read Section 1, Rule 112. And now they fail to implement the intent of the law. In subparagraph A, Section 3 of Rule 112. They will not accept any government official authorized by law to administer an oath. They will insist on an oath being administered by another prosecutor, if not by them. Now, let me just remind you, ladies and gentlemen of the class, there is a little thing called Section 6 of Rule 1. These rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. If the party can subscribe it before the punong barangay of his place or her place, why would you require them to bring their entire entourage of one complainant and probably 5 witnesses, 6 people, to go to the town proper and look for a prosecutor? Can you not allow them to subscribe it before their barangay and just one person, the complainant, to bring all these affidavits to the prosecution office? Will that be expensive? Or will that be inexpensive as compared to the other scenario? What do you think? See, this is how you should read the rules. Push against authority. Question authority. Why do they practice it in such a manner? When the rules are clear that it can be done. I'm passionate about this because I handled the case when this was put into issue. And I prevailed. Why? Because I have the law to cite. It's the black letter of the law against practice. All the prosecutor could come up with is, when I became prosecutor, that was the practice. We require all affidavits to be sworn before a prosecutor or another prosecutor. Wrong! Tradition does not make a law. Is it not? It's the law that speaks. A prosecutor or other government official authorized by law to administer an oath. You look at the revised administrative code, there is a list there of government officials authorized to administer an oath. It becomes very expensive. It looks like a field trip even What's the farthest town of Tarlac?
San Manuel.
Going towards Pangasinan.
San Manuel.
San Manuel. And where is the provincial prosecution office of Tarlac?
Yes.
San Vicente, sir.
Tarlac City. How much will it take for one person to get from San Manuel to the prosecution office? How much is the fare? Bus fare? 100? And how long will it take? How many hours? 1 hour? Okay. So you see, that's 100 pesos per person. 1 hour of that person's life. Coming from San Manuel to file a case here at the Tarlac Provincial Prosecution Office. And then you bring 6 people with you, your witnesses, so that they can subscribe before the prosecutor. Because the prosecution office will not accept an affidavit sworn before another person equally authorized by law as he to administer an oath. So if you bring 6 witnesses, you waste 600 pesos of that person's money. And sometimes they get here at lunchtime, or they travel for 1 hour and wait for 2 hours because the fiscal is having a trial in court. Because he will not allow anybody else to administer the oath. They have to wait for him until he finishes his court appearance and then goes back to his office. That's the only time he can cater to them. So, lunchtime. The complainant is now in a dilemma. If I don't feed these people, they'll get hungry and they will remember him. And then they will not appear during the trial because they will fear the same experience. Is that not normal and human? You see, it complicates a lot of matters. Now, those of you who work in courts, raise your hand. Have you ever seen a complaint or affidavit of witness that was administered, that was subscribed before another government official other than a prosecutor? Have you? No. Have you? I challenge you to look for one. Why? Because everything in the Philippines seems to be a turf war. Everybody is jealous over what little governmental powers they have. And they guard it zealously as if it's going to be a matter of life and death if it were not followed to the letter. And yet they cannot point to any black letter of the law. All they can point to is tradition and office practice. Can that prevail over the black letter of the law? Of course it cannot. But they make people's lives miserable and they make litigation expensive because of these wrong practices. In the case I handled, the prosecutor left the court red-faced because the judge saw my point. We have to make prosecution or judicial proceedings inexpensive. That's what the rule says. Or in the absence of the prosecutors in that prosecution office. For example, since it is the norm these days to have a yearly team building, all they do is drink, play games, roll around in the sand, take night swimming, and no team spirit is built. I assure you, for every team building, you see you're laughing, those of you who work in government and are prone to this, every team building, you go to a beach, you go to a faraway place, in order to have your team spirit built around that experience. But when you go back to your home provinces, there's a lot of bickering and backstabbing. Uy, alam mo si ganito, ang takaw sa atin. Is that not true? Ay, si ganito, nawala sa bigin. Naglakad kunyari sa beach, but they disappeared in the dark. And when they came back, the lady had sand on her back.
Gusto na lang magkakabasa.
That's what happens. Oh, the prosecution office, yearly, they do a team building seminar or whatever they call it. And then the complainant wants to file a complaint and nobody's there to administer it out. So they go to a notary public because that's what the rule says. In their absence, you can go to a notary public to have the complaint subscribed. Complaint and the affidavits are subscribed by the notary public, who is very happy with this newfound business. And he wishes the bus that the prosecutors wrote on will fall off the cliff. This is good business. You charge 100 per affidavit, there are 7, I have 700 in an instant. Alright. So he subscribes it, and the complainant proceeds to make the skeletal force receive the complaint. You think the prosecutor will immediately accept that these affidavits were notarized before a notary public? No. You know what he will require? He will require from the complainant or any of the parties interested a certificate that no prosecutor was available at that time, that it was subscribed before a notary public. How stupid can you get? You knew you were out of town, and then you ask somebody to certify that you were out of town. That's the problem.
Ganun talagang Philippines.
Our problem as a nation seems to be that we take whatever little governmental power we are entrusted with and wield it as if it was the greatest power ever, forgetting an old Japanese proverb that he who wields power the lightest wields it the best. See? I don't know what's wrong with us. We are penchants for power and authority. That's why so many people volunteer for government to be given just a small authority to perform an act as a public authority. You see how many people are volunteering even in the barangay? Just to be able to wield that small power of directing traffic. This is what they do. This is not. And during fiestas, to be able to tell people to fall in line. There are no salaries there in the barangay. Everybody wants to be identified as a barangay official. They have these shirts like blue for VHWs, yellow for mother leaders, pink for Lingap Sanayon, black and camouflage for the barangay tanod, notwithstanding that there is a criminal penalty for wearing unauthorized military uniform. Everybody seems to have a color code participating in what little power they can get from the government. You go to a barangay hall, any barangay hall, they look like a potpourri of flowers with all the colors of their uniform. They look like parrots. But that's Filipino. That's our way of life. So many people want to become part of government even if you derive no salary. You look at the police force. They have so many civilians. They're using as assets, runners, and whatever. They use them in police operations. This is the problem. And then, who suffers? The litigants. Alright? So in administering an oath, there must be a certification that the affiant had been personally examined. You look at the rules. So after that, within 10 days, the investigating prosecutor will determine whether there is enough ground for the investigation to proceed or dismiss the case. If there is enough ground for the case to proceed, they will issue a subpoena. And then the subpoena is sent to the respondent. So he has 10 days from receipt to file his countervailing evidence. But a lot of times this is not followed. Because even though the prosecutor says you answer it within 10 days, you file your counter affidavit within 10 days, when the respondent goes to the prosecution office within 10 days to file his counter affidavit, the prosecutor is not there. He's either out or he's either in the RTC. You know what they will tell you in the prosecution office? Just come back on the scheduled preliminary investigation. And then you subscribe your counter affidavit. What is the 10-day period to file your counter affidavit for? Nothing. Almost usually, it's submitted on the same day as the preliminary investigation. So the respondent is imbued with certain rights during preliminary investigation, which is you cannot terminate the preliminary investigation abruptly and arbitrarily. He also has the right to examine the evidence. The evidence submitted by the complainant to the prosecutor. In my case, I have seen subpoena with the complaint affidavit, but without the annexes. And I sent my staff along with the client to the prosecution office to obtain copies of the annexes. And then you have a minor office functionary, a staff of the prosecution office, who will give them a hard time and insist that he was the one who sent it at the matter at the post office, and that he should be photocopied and gave or sent copies of the annexes, but actually he did not. And then he will allow them to photocopy the annexes anyway. The respondent has all that. He also has the right to bring his own witnesses. Now, if an object evidence is to be submitted, like a bolo or a firearm, it may not be, of course you cannot make copies of these, but it will be made available at the prosecution office for the inspection, photographing, or videoing of the respondent. Now, after the counter affidavit, as well as the affidavit of the respondent, have been filed before the prosecution office, the prosecution office can already submit the case for resolution. Actually, that's the rule. If you look at the 2008 Manual of Prosecutors, the preliminary investigation should end with the submission of the counter affidavit. The submission of a reply affidavit and rejoinder affidavit are optional, and they can only be availed of if the investigating prosecutor agrees with the complainant that there is a need to clarify and answer matters raised in the counter affidavit of the respondent. If there is none, no need for a reply affidavit. And the prosecutor conducting the preliminary investigation may not grant the motion to file a reply, because that's an exception. However, what's the practice? The practice is automatic. As long as the respondent has filed a counter affidavit, automatically the complainant is given the same period of time to file a reply affidavit. And then, after receipt of the reply affidavit, the respondent is also given a chance to file his rejoinder affidavit. And only then will the case be deemed submitted for resolution. Now, What's the catch here? Why is that being practiced in the prosecutor's office? To buy time, to prolong the process so they don't have to work on making a resolution right away. See? They keep throwing back the ball to the parties to dribble the time. See? So, the ideal situation is after the counter affidavit is submitted for resolution. So after that, before he submits the case for resolution, the investigating prosecutor can set a date for clarificatory hearing. So what's the clarificatory hearing all about? He can ask questions to clarify matters stated in the affidavits of both sides, of both parties. Now, if any of the counsels attending such clarificatory hearing would like to ask questions of the complainant and his or her witnesses on one side, or of the respondent, or of his or her witnesses on the other side, they cannot ask these questions directly. They can submit a list of questions to the prosecutor. And it will be up to the prosecutor to choose whether to ask any of those questions to the witness, or to the complainant, or to the respondent, or to his witnesses, and all. It's not mandatory. If he does not want to ask questions, because the only thing he needs to clarify are those questions hanging in his head. But as to the questions of the counsels, he doesn't need to satisfy that. But there are prosecutors who will ask it anyway. And then and only then will the case be submitted for resolution. Let's leave it there for a while. Let's go to a preliminary investigation conducted by the judge, by a municipal judge. 2 words for a municipal trial court here. Do you conduct preliminary investigation, your judge? No more. Before the DOJ had prosecutors in all provinces and in all cities, judges used to conduct preliminary investigations, even of cases falling within the exclusive original jurisdiction of the RTC. The process they undergo is the same as that by the prosecutor. Exactly similar process, but with a difference. That's why I told you, keep this in your mental back burner for a while, and I'll get back to this, because I need to point out something that was a very distinct advantage before. You will remember under the Constitution that only judges are authorized to issue warrants of arrest. When municipal trial court judges are the ones conducting preliminary investigation, you have here a fusion into one person of 2 distinct powers. The power to conduct a preliminary investigation and the power to issue a warrant of arrest. So there was a very big advantage on the part of the complainant if you wanted the accused to be detained right away, because the accused might transfer to another province or skip the country altogether completely. So you want to file your case before the municipal trial court judge with a motion for the issuance of a warrant of arrest. And immediately upon receipt, the judge can call your witnesses and your complainant, conduct searching questions and answers, and after satisfying probable cause for the issuance of a warrant of arrest, meaning the elements are there, the eyewitnesses were able to establish them, there's enough evidence, the judge can immediately issue a warrant of arrest. So while the case will undergo preliminary investigation, the accused is already detained. That's the advantage. The accused cannot go into hiding. The because the municipal trial court judge can act swiftly. This is something that a prosecutor can never do. Even the highest prosecutor is not empowered to issue a warrant of arrest. That's a very distinct power. It can only be wielded by a judge. So after the municipal trial court judge conducting a preliminary investigation makes his resolution, it's the same process as the prosecutor. For the prosecutor, his resolution will be reviewed internally by a reviewing prosecutor before it is sent to the provincial or city prosecutor for signature. In the case of the municipal judge, his resolution will be reviewed by the reviewing prosecutor, and if it deserves merit, then it is sent to the provincial or city prosecutor. In both instances, the resolution may be reversed. The recommendation for the filing of a criminal action or information in court may be reversed on review. And so what the prosecutor does is it will dismiss the case entirely. The same thing is true with the judge. But if it is approved and the attached informations are approved, then they will be filed in the proper court. Take note of that. Every information filed in court must be approved by the city or provincial prosecutor. Any questions so far? Look at the periods involved. Now, Section 6 of Rule 112, look at that. In Section 6 of Rule 112, this is what we used to call a motion for judicial determination of probable cause. The rule says that within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. That's why it's called a motion for judicial determination of probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested, pursuant to a warrant issued by the judge. This is a municipal trial court judge who conducted the preliminary investigation or when the complaint or information was filed pursuant to Section 7 of the rule. Section 7 of Rule 112 speaks of warrantless arrest, a valid warrantless arrest, meaning that the investigation came from inquest proceedings. That's Section 7, Rule 112. Now let me dichotomize that for you. When a prosecutor finds probable cause to file an information against the accused in court, what they call an indictment, with a silent letter C before the T, they look for probable guilt. Or rather, they should look for probable guilt. But as I told you, what the prosecutors use as basis for filing a criminal action in court now is probable cause. So there is a sea of difference. Section 6 can correct that. Because the judge can look at the case and the evidence that were submitted and determine whether there is probable cause. In other words, there's a difference. The prosecutor should look for probable guilt to engender a well-founded belief that a crime has been committed, so he needs to establish that a crime has been committed, or that the acts attributed to the respondent constitutes a crime, and that the respondent is probably guilty thereof. So establish that there was a crime, or that the series of acts are indeed a crime, and that the respondent was the one who committed it, or probably guilty thereof, and should be held for trial. That's the mindset of the prosecutor. The mindset of the judge is different. Notice the use of the term probable cause here in Section 6, Rule 112, instead of probable guilt. The probable cause refers to the issuance of a warrant, not to the guilt of the accused. Remember what the rule says. The rule says the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. This is from the mindset of the judge. What the judge is looking for at this time is, will this case survive the test of evidence? Will this case present me with proof beyond reasonable doubt so that I can convict the accused? If not, I might as well dismiss it now. That's the mindset. The mindset of the prosecutor is, do I have enough grounds to file it in court? And the court, within 10 days from receipt, should evaluate the evidence. See, personally evaluate the evidence. And see, and look at the prosecutor if he has enough grounds to proceed with the case. If there is none, the judge can outrightly dismiss the case. If there is probable cause, the judge will issue a warrant. Now, let's jump ahead, because we need to relate it to this. Under the guidelines of continuous trial, a motion for determination, for judicial determination of probable cause may fall under the category of an unmeritorious motion, which under the guidelines may be immediately denied by the court. Outrightly denied is the word used. However, if such a motion was filed where the accused was denied a preliminary investigation, or that although accorded with preliminary investigation, the same was abruptly or arbitrarily ended, whereby the respondent or the accused was not able to fully ventilate his evidence during preliminary investigation, then it becomes a meritorious motion. Also, a meritorious motion must have been filed within 10 days from receipt by the court of the case and the information. Outside of that, the court can outrightly deny. And of course, you have to understand that under the Local Government Code, or RA 7160, when the crime or offense is punishable by a imprisonment not exceeding 1 year, the complaint must first be filed with the barangay. Without the barangay certificate to file action, it should not be filed with the prosecutor's office yet and with the court. However, if it reaches the court without a barangay certificate to file action, or it reaches the prosecution office without a barangay certificate to file action, the court as well as the barangay should not immediately dismiss the case for failure to comply with a prerequisite. Why? The court must look into the particular case involved, because there are cases, in cases of light offenses, which will expire within a period of 2 months. And if you go through the barangay, sometimes there is not enough time left before the case is filed, and so therefore it becomes expired or it prescribes. Remember that unlike the prosecution service, which conducts mandatory preliminary investigation in applicable cases, a barangay conciliation proceedings under Section 412 of RA 7160, the Local Government Code, is not considered a judicial process. And therefore, the reglementary period for filing the action is not told. So sometimes the police conducting the investigation or the complainant is in a hurry to file it because it might prescribe. What the court and the prosecution ought to do is not to dismiss the case, but just refer it back to the barangay. That way, the case does not prescribe. Just take note of that. Any questions so far? Sometimes I have to monitor this. So, take note of that portion of the law where the judge, the regional trial court judge, will look at the evidence, evaluate it. If you work for an RTC, always remind your judges about this, especially in drug cases. You should have your checklist already. Judge, is there a chain of custody document? There's none. That's one X. Just like in America's Got Talent. One X. Why? Where is this chain of custody document required? The chain of custody document is required in drug cases and in cases where there is object evidence. And that is prescribed in the police manual and has been required under the decision of the Supreme Court. The most recent and the most applicable, I think, would be the case of Romy Lim, where the Supreme Court also ruled on the matter of the witnesses to the inventory. So, do we have a chain of custody document? X. Now, what do you require of the prosecutor of that? Explain why there was no chain of custody document. Next. Was there a certificate or sort certification issued by the forensic chemist who conducted the laboratory examination? There is none. X again. What is the action required? Require the prosecutor to explain why there is no separate sort certification executed within 24 hours from the conduct of the examination. What should a sort certification of the chemist contain in drug cases? It must contain what time did they receive the specimens, what was the condition, what sort of chemical examination did they conduct. Did they conduct the Marquis test right away? Or did they conduct the Brown's reagents test right away? the Marquis test is necessary to isolate which chemical group the specimen falls under. And then you apply the specific test for that. If it is methamphetamine hydrochloride, then you go into Brown's reagent test. It's called a color test. I'll explain what's in that certification. If not, then most likely the operation was irregular. The judge may dismiss that. But I don't think a judge will readily dismiss drug cases during this administration. Then you look further. When the police officers graduates of anti-drug schoolings or seminars, because that is required in the 2010 Manual for Anti-Illegal Drug Operations of the National Police Commission. Were they led by a police commission officer? If not, another age. When they accumulate enough excess, dismiss the case because you can no longer comply with the elements of the crime. And that falls under Section 6 of Rule 112. Now, if a case does not require preliminary investigation and it is filed in the prosecutor's office, the prosecutor can act on the complaint. He is not prescribed or proscribed. If it is filed directly with the court, the municipal trial court, then because it was filed with the municipal trial court and there is no required preliminary investigation, it may still set the ball in motion by requiring a countervailing evidence from the respondents. And the process will start again. So now we have an information, the product of inquest proceedings or preliminary investigation in cases where a preliminary investigation is required. We have now the information filed before. The judge within 10 days will conduct an evaluation of the evidence and determine if there is enough ground for the case to proceed, without which you can dismiss the case, or if there is enough ground to proceed with the case, issue a subpoena for the rest of the accused unless the accused is already in detention. Remember that there are two types of certification that you have to look for in an information filed to the court. If it is the product of preliminary investigation, the provincial prosecutor or city prosecutor will certify that the case had undergone preliminary investigation pursuant to Section 3, Rule 112 of the Rules of Court, etc., etc. If it is the product of an inquest proceeding, the provincial or city prosecutor will certify that the case had undergone inquest proceeding under Section 7 of Rule 112, and that, etc., etc. There is a distinction there. Now, if the accused is, the respondent is supposed to undergo inquest proceedings, meaning summary, but he waives the applicability of Article 125 of the revised penal code. What's Article 125? Delay in delivery to judicial authority. And then he requests to be allowed to submit his counter affidavit. And then it is granted. But all of a sudden, the prosecutor resolves the case without his counter affidavit while it's still within the time granted for the filing thereof, and files the case in court. the accused can file a motion for investigation to bring it back to the prosecutor's office in order to allow the said accused to file his rebutting or countervailing evidence. Now, why is this important? Why is it important to know the distinctions here? Can the prosecutor act on a motion for reconsideration of his or her resolution after the information was filed in court? For example, in the question of Mr. Armas, instead of appealing to the Secretary of Justice by way of petition for review, what the accused did was file a motion for reconsideration with the prosecutor's office and use that as the basis to ask the court to suspend the arraignment of the accused. Will that work?
No.
Why not?
All pending, once the case is filed in court, all pending incident must be resolved by the court. Crespo versus Bumor.
That's
So
right.
that particular motion is not considered proper. In other words, that motion is meaningless.
When the information or complaint is filed in court, the prosecutor's office loses its jurisdiction.
Yes.
It can no longer act on any motion for reconsideration. A lot of lawyers commit that mistake. They file a motion for reconsideration, and when the arraignment comes, they use that as a ground for the judge to suspend the arraignment. Your Honor, we filed a motion for reconsideration with the prosecutor's office. May we be given time to await the results thereof. If you were the judge, you immediately deny it. That's not one of the grounds, and that's not what the rules contemplate.
The prosecutor, sir, must attend the lecture of Professor Tigara. So that he will not commit mistake. That's a blunder.
Usually,
His diploma from the Supreme Court must be surrendered. Yes, that's true.
a lot of lawyers commit that mistake, by the way. So the proper thing to do is file a petition for review before the Secretary of Justice. And then present that to the court at the arraignment. The court will give you 60 days. But after 60 days, if you still want the arraignment to be suspended, you should be able to file a certification and show to the court that you're not wasting its time, that the Secretary of Justice has given due course to your petition for review. And it will be the other way around. It will be the reverse. Because if the court proceeds with the arraignment, pre-trial, and the trial, and thereafter the Secretary of Justice issues an order of decision directing the withdrawal of the information before the RTC or MTC, then the court already wasted its time. That's why that certification is very important. In the case of Crespo versus Mogul, the situation was after the resolution, the accused filed a motion for reconsideration with the prosecutor's office. That happened in the city of Manila. But the court denied it and proceeded with the arraignment. They questioned it before the Supreme Court. This was at the time when you can directly appeal to the Supreme Court on pure questions of law. Now you can't do that. You have to go to the Court of Appeals, even on pure questions of law, unless you fall under any of those enumerations which I gave you last semester. And the Supreme Court said once the information is filed in court, it is the court that already has jurisdiction over it. The prosecution office will lose all authority to act upon any pending matter, even unresolved. That was decided in the 1960s. It's still good though. We don't need exact citation. Just say Crespo versus Mogul, and the examiner will, or the judge will know it right away. Let's have a 5-minute break before we go into rest. Or rather, Rule 113 is, you say you go to play. You study calligraphy.